the requisite 60 state ratifications took place, the Rome Statute came into force, and the ICC was formally created on the 1st of July 2002. A new permanent international organization was born, independent of the United Nations or any other pre-existing body. With good reason, it was said that this was the most significant development in international law since the adoption of the United Nations Charter. At the center of this new system of the Rome Statute is the principle of complementarity. This means that the ICC does not and cannot replace national justice systems, but it only complements them. It is the national jurisdictions that have the primary duty or responsibilities to investigate and prosecute the Rome Statute crimes. The ICC only has jurisdiction over these crimes when states are unable or unwilling to carry out genuine investigations or prosecution. In other words, the ICC is a court of last resort with sufficient resources to focus only on the high-ranking suspects and the most serious crimes. In a way, the ICC is a ship that is being called upon to prosecute and try the big fish who have escaped the fishing nets of national legal systems. As such, the key challenge in terms of complementarity is to strengthen the national capacity to investigate and prosecute the Rome Statute crimes. Together with the principle of complementarity, another key aspect of the Rome Statute is the ICC's reliance on states parties to cooperate with the ICC so that it may carry out its mandate. The ICC does not have its own law enforcement forces or even prisons at its disposal. From the opening of an investigation to arrest, to the protection of witnesses and the enforcement of a sentence, the ICC needs the cooperation and judicial assistance of the competent authorities of the states parties at every step of the way. Unfortunately, such cooperation by states has not always been forthcoming. There are currently 11 outstanding arrest warrants issued by the ICC. Many of them issued several years ago. Moreover, only a handful of states have concluded agreements on relocation of witnesses or enforcement of sentences with the ICC. Given the ever-increasing activities at the ICC, greater involvement and commitment of states in these matters is a priority. The main obstacles in terms of state cooperation are usually of political nature. If there is will, there is a way.